Hi, everybody. My name is Cassandra Johnson. I'm actually going to share my screen for you all. Thank you for joining us this morning or this afternoon, wherever you're at, for our 30 Years of Model Courts and Implementation Sites webinar. We're excited to have you here. I'm just here to bring us in, and then we'll have our lovely three judges here to talk with you. I know that Fabi had mentioned that if you have any questions, you can put them in the chat or raise your hand. We are reserving questions for the end, but if you put them in the chat or the Q&A, we will make sure to field those and give those to our presenters as time allows at the end. As part of our lovely process, I have a disclaimer to let you know that the presentation is supported by a cooperative agreement with OJJDP, and the points and views or opinions expressed in this presentation are those of the presenters and not necessarily represent the official position or policies of OJJDP or the U.S. Department of Justice. Today, we have three presenters who I'm just going to introduce their names and titles, and as they're talking, they will tell you a little bit more about themselves. But we have retired Judge Ernestine Gray from Orleans Parish, Louisiana. We have retired Judge Stephen Rubin from Pima County, Arizona, and current sitting Judge Beth Dixon, who's in Rowan County, North Carolina. So they'll tell you a little bit more about themselves as they go along. But here's our learning objectives for the day that we hope you have by the end of this presentation. We hope that you'll understand the need of the model court movement and improvements in child abuse and neglect cases. I hope you can identify key strategies that the model courts use to improve practice and how innovation led to critical change. And hopefully explore innovative changes still needed to improve our outcomes for children and families. All right, and I will pass it off to Judge Rubin and Judge Gray.
Hello, everyone. It's my responsibility to talk a little bit about what the model court movement was. And so it was an effort by the National Council of Juvenile and Family Court Judges to help judges around the country improve the practice and the outcomes for children and families in child welfare cases. And it grew out of the Adoption Assistance in Child Welfare Act at the time, which there was showing there was a great need for courts to know about their help to improve the agency recommendations, the work with the departments, and to prevent services to avoid unnecessary removal of children. And some of you, I'm sure, were not judges at the time because the judges are younger, but a lot of them are younger than I am and have come to the bench many years after 1980. But in 1980, there was this growing concern about children languishing in foster care and not getting permanency. And so while the courts that signed up to do the work were not necessarily models of best practice, they were willing to put themselves under what I describe as a microscope and have other judges and the council look at their work and help make recommendations to do better work. And so in 1995, this movement was launched, the Model Court Project, funded, and Fabi already talked about, Cassandra already talked about it being funded by OJJDP. And so that's how we started, and it's thankfully continued and moving forward into 2026. Next slide. Steve, that's you.
Yeah, I'm here. Yeah, people see these things, for example, the key strategies like judicial leadership. And back in the day when we were starting on this, people were saying, and some still say, well, judicial leadership, what is that? Why are judges taking active roles in this? Because really the system was such that these cases were usually run by the agency and not by the court. And the council put together the best practices implementation based on the resource guidelines that were finalized in 1995. The guidelines were a book that was trying to show everyone how badly things are going and how much we need to do better around best practices to get these cases going. When I was on the bench at first, in these cases, nothing ever happened. There was no continuity, there were no guidelines, and we needed those guidelines. The guidelines have been codified essentially in federal law, and the federal law surrounding child welfare has changed dramatically as a result of the initial resource guidelines. Case flow management is also a key strategy. Timely decision making. We can't kick cases down the road. That would always happen pre-resource guidelines, is that people would come in for their first hearing and one judge would say, okay, you'll come back in 90 days. And then on that 90 days, there would be another judge, and nothing really ever happened. Nothing went well. The strategies here also are bringing together stakeholders and collaboration, and judges working with the agencies, attorneys, CASAs, GALs, really everybody. As I look at the list of people and groups that we used when we started our collaboration, we brought in everyone that was involved. We brought in the police, we brought in social workers, we brought in the organizations that were going to provide the services needed for families, the welfare of children, everybody, all the stakeholders. And as that list of that group of stakeholders got together, it continued to get better and better by bringing everybody in as groups. We conducted meetings every month for 14 years to go over this collaboration all the time, make sure everybody's on board and are working together for the betterment of the children and families that we were serving. We're trying to focus on outcomes and performance measurement, and we had good data to figure out how we were doing. The goals of the program obviously are always child safety, timely permanency, and family well-being, reducing delays. I was just talking about that. There were so many delays when we had the pre-resource guidelines. People would come in, for example, and they would say, my client just tested negative yesterday, and so we want to continue this case for another 3 months. There were no guardrails, there were no timelines that needed to be appropriate, and that increased the length of time children were in foster care and the length of time that cases got ended. Multiple improvements were made in child welfare court practice, and there's a whole list of new things that were done and what our goals were. Our goals were to follow the law, which includes federal law and state law. Judge Gray just mentioned what some of those important laws were that helped us get to this. And by taking a group of courts to start as kind of the guinea pigs for the system, we went through creating new improvements to the system. We started off with, low-hanging fruit, like timely court hearings and a whole list of other things. And we discovered then over time that we did create numerous improvements. And as we continued through the process over the years we were doing it, more and more improvements and more tools for lawyers and judges and stakeholders to help decrease the need for foster care and improve the outcomes for the children and families that we serve.
So I think next slide is mine. Just to sort of summary and in summary and to get us to where we want to go really is to talk about implementation and moving forward in 2026. But before we do that, we wanted to just acknowledge the work that was done in the beginning years. So this project was launched in 1992, and one of the known as the Victims Model Courts Project. And one of the key things that we did, Judge Rubin has already mentioned this, was develop and produce the resource guidelines. And it took from 1992 to 1995 to get that document in a position where the National Council was satisfied that, it was the document that needed to be produced and that it would be helpful to judges around the country. And so with the support of OJJDP, the document was produced and disseminated. And of course, it was the resource that was used by the courts who agreed to be, as Judge Rubin referred to them, the guinea pigs. It was our Bible, as I would say it that way, because, it outlined what was supposed to happen at every hearing. It talked about a lot of key issues and provided lots of great resources for the judges. And then in 2016, we did the enhanced resource guidelines, which was an update, again, funded by OJJDP. And it, again, supported the work in the field, made available not only to the model court judges, but to all the judges around the country. It was given out at many, many trainings that the National Council had, and to other organizations as well. We would have a table, we would have the resource guidelines, the enhanced resource guidelines, available for people to take with them. Now, what I would say is it's not a light carry. This is a heavy book. And so when people came to conferences and it was made available, then you had to figure out how do you get them back home. And one of the things I remember is when we were a model court, you could get, because Judge Rubin talked about our teams, you could get a copy for each of your team members. And again, you couldn't really take that on the plane because it weighed a lot, and then you had to pay to have it shipped. But all that aside, it continues to be, in my opinion, a great resource for judges, both old and new, who are still doing the work, because we sometimes slip, forget, and we need reminders. And so the book, those publications, I think, are really great still tools for judges.
I think you guys were going to share this one, but you don't have to talk too much on it.
Yeah, well, I want to talk a little bit, just a little bit more about the enhanced resource guidelines. We took together all the things that we had learned from the resource guidelines, and as things changed, there became a need for an update on what is happening. Significant changes in federal law occurred, and innovations done by the original resource guidelines brought on other innovations and other strategies. That was published in 2016. Unlike the resource guidelines, which took 3 years, the enhanced resource guidelines took us almost 6 years to do, because at that point in time, the federal law was going crazy over this. So there were new federal laws coming at us everywhere. We thought we had it completely finished. And then just as it was being ready to go, then another federal law came along that was really new and critical that we had to stop and add back. The other important thing is having a book that a judge or a lawyer can open up and go through and actually really learn, especially for a judge, really learn exactly how to handle these kinds of cases, to be in compliance with federal law and state law, and the initiatives that had taken place to uh, to improve outcomes for the children and families that we serve. And there's a list here about the various federal laws that have been parts of the resource guidelines.
So I think the important thing about this slide is the history. And when we were preparing for this presentation, Judge Rubin, remember you mentioned the very first piece of history about this work in child welfare was in 1847. And it was based on the prevention of cruelty to animals. And so we use that language from that act to talk about protection of children. And so we have a long history, and important things have happened over the years. And even today, we know we need to be aware of changes in the law and all of those kinds of things and how they impact the work that we do. And so having a place where judges can go and learn from each other, I think is critically important, and I really support that. I think I know that I would not have been the judge that I was without this work.
Can I go back there to one important thing that we need to talk about? 1974, the Child Abuse Prevention and Treatment Act, CAPTA, transformed the judicial role from a passive arbiter to an active guardian of child welfare. And this is a law that had to be done because these cases were not run by judges. They were basically run by the Child Welfare Agency. And judges really kind of were rubber stamps of the agency's take on the case. So this really allowed judges to come to be in charge of these cases, that these were judicially led cases. They were not social worker led. They were not lawyer led. They were judicially led. And that gave judges an opportunity to really take an interest in and work through these kinds of cases.
And so this slide just shows the original model court sites. And I think the one thing that we haven't mentioned so far is that a lot of this work was based on work that was coming out of Cincinnati, Ohio. They were the model that became the model for the work that we were doing. And so this slide shows where the original sites were. I think you can go to the next one. And again, adding in more sites, this is more of where the sites were. And you can see the number of sites is growing over the years. And we have included, we've included Native American. So you have the Mississippi Band, Choctaw Indian Nation. You have a couple of Native American courts that are a part of the Model Court Initiative as well. And following, I'll just keep talking, following the model court, you have then the implementation sites. And so these are the sites that are currently working with NCJ, FCJ, and attempting to implement both the work in the resource guidelines and the enhanced resource guidelines, and still being guinea pigs. So to see how it really works, and then to push out that information to other courts. There are also mentor sites where courts who have been model courts in the past agree that they will work with newer courts and provide some assistance to the newer courts in trying to implement the guidelines.
Now you guys have time to share.
Time to share.
Time to share. Well, so I'll talk. So I went on the bench in 1984, and thought I was doing okay. I hadn't had any complaints filed or anything. I'd had a couple of appeals, but I'd been confirmed, so I thought I was rocking and rolling. And then in 1997, there was this article, and I talk about it all the time, in the New York Times that said our court was the worst juvenile court in the nation. And I took offense to that. And that is what jettisoned me to become more involved in the National Council, to seek to be a model court. Not that I was doing things right. Obviously, if the New York Times article was correct, I was not doing anything correct. But I wanted to be a model court because as I understood the work of the Model Court Initiative, it was to help me do a better job as a judge. And so I became a model court and really, as I've said so many times, I think that was the thing that helped me to become the judge that I ended up being when I retired in December 2020. And so for me, a lot of the goals, a lot of the projects that were talked about were really helpful. So in the article, one of the things they talked about was, Judge Rubin mentioned it, the irregularity at which the cases were coming to court, the failure to make timely decisions, children languishing in foster care. And so when I went to come out of court work, I was impressed by the courts that had projects that were addressing some of the issues that were plaguing me. So right away, based on the idea that, I couldn't do it myself, I did develop what we call the model court team, which consisted of all of the stakeholders, the department, the lawyers, the social worker, the attorneys, CASA, and service providers. And we met on a monthly basis to talk about the issues that we felt we needed to address in order to improve our practice and get better outcomes for children and families. And so some of the things that I learned and borrowed, or as we used to say, steal from other jurisdictions were things like time certain docketing of cases. So, prior to that, we said everything at 9 o'clock and just ran through until people were exhausted and, people waited a long time in court. And so one of the things I implemented was this time certain calendaring of your cases. I also implemented a no continuance rule because, again, we were tagged with languishing cases. And so things like that really helped to improve the work and get us on a better pace to doing what turned out to be best practices for families. And we could see when we started doing that, we saw that cases were moving a lot quicker. I was able to get to a point at some point, not originally, where I was able to see all of my cases at 30 days. That was an accomplishment. People didn't think it could be done. There was pushback from the department and from the social workers. But what I quickly saw was that for a lot of the cases, no work was done until it was about time to come back to court. And so I felt, okay, if that's the way we work, then you have to come back to court more often. You're not going to do anything for 6 months, and then in the 5th month, you're going to do a lot of stuff. Then we come on more often. And so I just decided we would have our case reviews every 30 days. And there was a lot of concern about whether or not we could do it. We actually did. One of the things I did was, so if we moved a case to termination, we had an adoption was the goal, and we had an adoption placement, and everything was in place. A perk was that if you got your case to adoption, we had a date set, then you didn't have to come back to court until it was time for the adoption. And I'm talking about adoptions. One of the things we started doing was recognizing the adoptions that we did during the year. And that was something I picked up from, I guess it was Los Angeles. Judge Nash started the Adoption Day project. I adopted that. I adopted from Chicago, uh, um, working with older youth, and having them come to court, not on a court date, but not on a regular court date, but set aside a date where I met with all the children aging out of foster care and talked to them individually about their goals, what they wanted to do, how we could help them. Um, and so it just was a wonderful experience where I met judges who were not selfish about the work they were doing and were committed not only to doing good work in their jurisdiction, but who had a real interest in trying to do work that would help improve the work nationally, which is what I think is commendable about all the course. And so that's what I got. That's why I tell people when I meet new judges that they should belong to the National Council of Juvenile and Family Court Judges and become active members and attend their conferences and take advantage of all the programs that are available to them. And they will be better judges for it. So I think I'll stop there and wait for questions.
I have some thoughts.
Yeah, go ahead.
There in the early days, our court was, one of the first, and in the early days we were trying to figure out to do the same things that Ernestine was doing. We were trying to figure out how we get this done and what's the fastest way to kickstart this and keep it going. And there was a book called Creating a Better Collaboration done by the National Council, and I think that's going to be updated here shortly. And the requirement really that we collaborate across all of the agencies. When we first had our site visit from the National Council, which is what happened when we came on board, a team from NCJ, FCJ, which included social workers, some social workers, lawyers, and other entities, to come to the court, to look at the court, to assess where we are and what the court is doing and what the court may need to be doing. And we started by saying, look, we need to start this. We're not going to fix everything today. We need to take a slow approach on finding ways to do this. And the team came, in our case, the team came to our court and they looked at what was happening. And we had PhDs coming in to help us. And the first thing that they looked at was, what does your calendar look like? What does the calendar look like for you as a judge in this case? And basically in our situation, our calendar looked like nothing because nothing ever happened. It would go on the calendar. One judge would come in and said, I mentioned this before. So the PhDs, Dr. Gutowski and Dr. Dobbin, came to our court, and we sat down in a room with a outline of the days of the week and the hours in the day. And we looked at how we could make these cases work in a timely manner. And we literally physically did that on a piece of paper. We sat in the room with the judges and the calendar, and we redesigned the entire way that the court handled these cases, including specific amounts of time for each of the court hearings that needed to be done in the case. And so that was the first thing that really was changed. And the agency, given the fact that we had created something called, a pre-hearing conference, which was one of the first things we then had them implement, was to have a conference outside of the judge's courtroom to see if they could quickly resolve some initial issues to get the family on the right track toward reunification. And of course, the agency at that point said, we can't do that, right, was their response to many of the things. And the we can't do that was, we wanted to have a hearing at 5 days after removal as the initial hearing. That was going to be a thorough hearing. And they said, well, there's no way we can do it in 5 days. And I said, well, we said, well, we're going to do it. We're going to change it, and we're going to do it. And begrudgingly, they agreed. And that set the stage for a much better collaboration with the agency for us, and a much quicker way to get things done. There's a tremendous list of innovations that have been taken away, that are takeaways from the resource guidelines and enhanced resource guidelines. Front-loading services. Nobody had ever thought of that at that point because they weren't front-loading anything. Front-loading services, mediation, so many different things that I can't even think of all of them anymore, that have gone through this. Taking our court to look at other courts to see if they're doing things different or better that we might be able to take away from that. All of those things building on themselves to create what we ended up creating, which was a very high functioning, timely situation, certainly in our courts and in many or most of the courts that were supported by the National Council's program.
So if I could, I'd just like to mention a couple of other things. So Stephen just mentioned the site visits, but also we would have all model court, all sites meetings where we would, all the model courts would be in a large room. And in addition to having provided some written documentation about what was happening, each site had an opportunity to talk and about what they were doing. And it was, like everybody wanted to be, have something to show. And so it became a sort of showcase. I'm going to top what they're doing. And so we learned that way. And so the site visits and to the local jurisdictions and the model courts, all sites meetings or opportunities where you had to talk in depth with the judges face to face about what they were doing. One of the things that innovations that I would like to hold up, and which is one that helped our court, was, and Judge Rubin mentioned this about the judges changing over, don't see the same judge all the time. And so that was one of the factors that led to delay. And so what we were able to do in Orleans is get permission from the Supreme Court to create a model court, to create a dependency division within the juvenile court. So at the beginning, I was doing delinquency and dependency. And after the article talking to the Supreme Court about how we wanted to improve the work, we got them to give us special permission to create this division. And 2 of the 6 judges went to the dependency division. And then we also adopted a one judge, one family. So if you got the case in the beginning, you kept it, right? So that it was your case. And to the extent it was not being processed timely, that was your issue. You had to deal with it. And so for us, the one judge, one family model helped make a big difference in our ability to see cases on a regular basis, to be consistent in what we're saying to the families, and be consistent in directives to the department about what should happen in individual cases.
Yeah. Another controversial piece of what we were doing was one family, one judge, and taking it through the entire way of a case. One of the other things we also did was when we had a family law case and a child welfare case that were going simultaneously in different divisions of the court. In our court, the family law bench was downtown and the juvenile bench was in another location, and they didn't do, downtown folks didn't do juvenile, and the juvenile folks didn't do family. The juvenile judges didn't do family, and those cases cross lines. So one of the things we were able to do, we were able to get a new court rule that said that a case that has both family law issues and dependency issues are heard by the dependency court judge. And that was something that was very controversial, but we got it happen and we got it passed. And that's made a huge difference in outcomes for kids.
Both for sharing your perspectives and your experience as a model court judge. We're actually going to switch gears now and hear from Judge Beth Dixon, who's our current implementation site judge.
Thank you. So I'm Beth Dixon. I am the Chief District Court Judge here in Rowan County, North Carolina. I am coming to you from our dedicated child welfare courtroom, and I hope that you can see a little bit of the beautiful mural behind me. That was actually one of the first big physical changes that we made to our courtroom setting as part of being an implementation site. So we became an implementation site here with the National Council during COVID. And honestly, it is the best thing that has ever happened to our child welfare courts. And we are the beneficiaries of Judge Rubin and Judge Gray and those judges that were part of that model court program that actually created the wheel for us. So instead of having to recreate the wheel, they have given us their insight and their expertise, and we know what the best practices are. And now as an implementation site, the National Council helps us figure out how we can make those best practices work in our courtrooms. One size doesn't fit all. We're not saying as an implementation site or National Council as part of this program that you have to adopt each and every process, that this is the way to do it and the only way to do it. We're also different. Our jurisdictions are different. Our resources are different. And so it is, how do you adapt those best practices to what is happening in your courtroom? So for me, it started anecdotally. I knew that we were not performing well. I didn't know anything about our data. I didn't know how to confirm my suspicions that we weren't doing the best job. And frankly, neither did any of my regular players in court. My defense, parent defenders, the DSS attorney, we were all just kind of doing it the way it had always been done, and it didn't seem efficient. So when the opportunity arose to be an implementation site, the first thing I did was go to our DSS director and ask for basically her blessing and willingness to collaborate on this effort. And while we talk a lot about judicial leadership, and we know that it is important and that is a judge-led change process, the fact of the matter is it's multidisciplinary, and you need a team and you need that collaboration from everybody. So it is not something that a judge does alone, that you put together your change team based on the stakeholders that are in your jurisdiction and put all those heads together in beginning your process. And honestly, it's not a comfortable process. You have to check your egos at the door. As Judge Rubin said, the National Council will bring their teams down and do a very thorough investigation of your court. They evaluate, let you know what your strengths are, what your weaknesses are, what you're doing well, what you're not doing well. And then as a collaboration based on that feedback, you can set some goals and then begin figuring out how you can reach those goals. And honestly, the expertise that is provided, the technical assistance, and the invaluable advice from the judges that have been doing this for now the past 30 years has just been phenomenal. And it's a process of change. It's a continuous quality improvement process. You evaluate, you implement a change by tweaking something, you measure, you reevaluate again, keep it in existence if it works. If it doesn't work, you tweak it again and reevaluate. It's a never-ending process, but you are just continuing to make your courts bigger and stronger, and until you achieve proficiency in meeting your benchmarks. My hunch was correct. When we started this implementation site, I learned that my district was experiencing an average days to adjudication of more than twice what our statutory mandate was, that our children were in foster care much longer than they probably should be, that we were missing all of our federal benchmarks. Our children were not receiving timely permanence, and we frankly ran out of court time frequently without completing our docket. So we had a very inefficient use of our court time. And I will say that one of the very best things about beginning this process is that it grounds us all back into that federal legislation, that landmark legislation of 1980, which was the Adoption Assistance and Child Welfare Act that Judge Rubin and Judge Gray referred to. And that is the federal act that put the supervision and oversight of child welfare systems in the courts. And so, and the court is not just the judge, the court is also all of those other stakeholders and players that are there. And to ground us back in that foundation and realize that this is important, not just because we want good outcomes for children, which is of primary importance, but because Congress instilled this, gave us this task back in 1980. And that the way that we carry that out is through our processes in court and our findings of reasonable doubt or no reasonable doubt. So I am happy to tell you a little bit about some of the things that we did here in Rowan County. And the goals that we set initially were to improve our timelines, to understand our data, to identify any gaps in services, and to obviously lessen the average stay in foster care. And we utilized the 10 key principles of the enhanced resource guidelines, which are the updated version of the resource guidelines, which really are the best practices and give you a framework in which to organize your court and goals to meet. So one of those key principles is keeping families together. And so the way that my court changed to do that is that we now mindfully consider moving safety resources into a home rather than moving a child out of the home. We have institutionalized searching for relative placement over foster care. And oftentimes a relative placement may not be allowed by policy of the Department of Social Services to be approved as a relative placement for a child. But we have hearings on that. And if proponents are able to convince the court that there's no safety risks for this child, just because a household member may have a 10-year-old driving while impaired charge, that we can override that policy of the Department of Social Services and place that child in what's found to be a safe family placement. So that has really decreased our dependence on foster care and increased our focus on families first and a kinship culture. So it's also important to us and a key factor for the process to ensure access to justice. And so we try to practice our procedural due process as much as possible, ensure that everybody's voice is heard. If somebody is not speaking up, ask them directly, is there anything else that you would like me to know? One of the things that I do to encourage parent participation as well as others is I allow remote participation. Meet families where they are. If you have an individual that is working and it was very difficult or is difficult for them to take 4 or 5 hours off to come sit in court for a while, allow them to call in, allow them to participate via, we use a WebEx facility here, but they can log on from their device and spend 15 minutes in court and be engaged and active in their case and their case planning. Another thing that we do is we prohibit drug testing on court days. And again, that encourages parents to appear and that they are not afraid of being caught doing something bad. And I try to encourage the families that, we're not trying to catch you doing bad, that if you test positive, you don't get punished for that. You're already suffering from the loss of your children, but that it's just a tool to help us determine the safety parameters that we are working with. We treat everybody with dignity and respect, and we utilize trauma-informed practices. And one of the first things that we worked on for a trauma-informed practice was the physical and emotional safety of my courtroom. And so we did make it more child-friendly, more welcoming. We had this beautiful mural painted. All of the images represent resilience and new growth, rebirth, resilience. And so it's we all enjoy working in this courtroom. It helps our own mental health as well. And anecdotally, the mural was painted by a former juvenile delinquent who is now sober, has been in recovery for over 15 years. And he used to be a tag artist and got in trouble for spray painting where he shouldn't. And this beautiful mural is actually all aerosol art. He did it in a weekend. It's all spray paint. And so the children and families love it. We have a bookcase in our courtroom, and all the children that attend court can pick out new books to take with them when they go home. We also give them to parents that are age-appropriate books to take and read during parenting time. We focus on cultivating cultural responsiveness. We ask families about their events, their holidays, their traditions, things that are important to know when we're contemplating parenting time, and when we're contemplating what times the children, may be able to have access to siblings and to extended family members. And we're mindful of the language needs of family and children. We have now a very convenient and dedicated language service and way that we schedule interpreters and ensure that cases don't have to be continued because we don't have appropriate language services. It's all online and very transparent. We're mindful of religious practices, families, and as well as the placement provider to ensure that we don't have any conflict with any of those things that could really be trying to a child to come out of one religious practice and go into something that's totally different from what they grew up with. And so we want to ensure that we keep that in mind as we're looking for best placements for children. As Judge Rubin indicated, that we have learned that alternative dispute resolution techniques are really important, that not every case should or has to go to an actual trial and adjudication, that we created an opportunity for pretrial negotiations for consent resolutions of adjudication and disposition. That has helped tremendously. We set it shortly after the first shelter hearing, placement hearing, after their service on at least one parent. If a consent's not reached, then that gives us plenty of time before that 60 days runs to be able to have an actual trial. But it gives parents a good voice into the resolution of their matter. And it has been really successful for us. And it has also helped us be much more efficient in our court time. So we no longer run out of court time during the day and not achieve something on each of the cases on our docket. We routinely review our data for benchmark timelines, permanency outcomes at every hearing, where we ask, as we were taught, to ask the placement or to ask the social worker in charge, what is preventing this child from safely returning home today? That's the crux of it. We can't dance around that issue. What is it? And how can we achieve that? And so that helps us plan for what we need to look at the next time we're in court. We begin every hearing by granting an overview of the child, the family, how they're doing. And so that was something I didn't do for 20 years until I was taught by the National Council in this project. I've been on the bench 24 years now. I'll say, we're calling the case of Johnny. Johnny is 6 years old. He has been in care now for 6 months. His mother's here, his father's here, and name them. He's doing really well in school. He has some intellectual disabilities, and we're working with his IEP. He's very healthy, recently had a dental checkup. So just a good overview. Everybody centers on, we're here about Johnny. This is the most important thing in our courtroom right now, is this young child, and everybody's invited up and given a voice as to what should happen for Johnny and his family. And ensuring adequate and appropriate family time is a big goal of ours. We have expanded our visitation options, but that's our number one goal for 2026. We review parenting time plans at every hearing. We consider allowing ample phone calls and video visits. We look for other appropriate visitation supervisors. We allow visits on court dates, even if it's very brief, and ask if there's any barriers with parents attending school award events, sporting events, award assemblies, and encourage the opportunity to see each other there as well. That we are trying to help our parent defenders feel better prepared and to be able to give better representation to the children and the families. And so I'm going to skip to what our actual improvements were, since we are running out of time. But during this process, we have reduced our average days of adjudication from 139 days to, at the time that I did this data, 53 days is our average days to adjudication. The ones we typically miss, we run between 75 and 80% compliance with the 60 days. The ones that we miss are typically due to service issues where the parents have disappeared and we've had to publish, where there is a jurisdiction issue and we are in communication with another state to see who's going to take the lead, or it's a complicated medical abuse case and it takes longer to get those doctors and nurses in to testify. We now track all the reasons that children enter care to ensure that we're using our limited resources wisely and that they are directed to the reasons that kids come into care. We have more children in kinship care than foster care now, and we have increased the number of youth leaving foster care each year. And just the process has turned me into a bit of a data geek. And so our permanency outcomes, the performance measures with children leaving foster care within 12 months, the standard from the Children's Bureau is 40.5%. My county is at 57.14%. Leaving foster care within the second 12 months, the standard is 43.6%. And we're just below that at 40%, but we do so good in that first 12 months. I give us a slide on that. After the 24 months, the standard is 30%, and we are at 34%. And one that I'm really proud of, because I think it speaks to the strength of the services that we are providing families, is reentry to foster care within 12 months. The national standard that we shoot for is 8.3%, and my county is at 1.14%. So we have made tremendous, significant progress, and it is honestly due to being an implementation site. And I encourage everybody to learn more about National Council and about the progress that you can make in your own jurisdictions. I'm a small jurisdiction, and we have just made massive progress. And as I was telling our panelists prior to this, North Carolina took over its 6th Department of Social Services Child Welfare Division today for lack of progress. And I guarantee if you're an implementation site, that's never going to happen to your county. So thank you. That's kind of all I had on that. So
You did great, Judge Dixon. Go ahead, Judge Gray.
Oh, no, I was saying great job.
Yes.
I want to go see her in action.
Oh yeah, we all do. We all enjoy seeing Judge Dixon on the bench.
That's great.
Yeah, it's just, it is proven. I mean, the work that the model courts put into it and the work that those judges did, you can see the fruits of your labor in my courts. So thank you very much for teaching us those lessons and allowing us to have the benefit of your hard work and wisdom, and we've taken your best practices and molded them to meet our needs in our jurisdictions.
Thank you, Judge.
Yeah, thanks.
Awesome. Thank you. We're right up at time. I think you guys did amazing. Our last slide is just a few thoughts for considerations for the field moving forward. We've kind of talked a lot about this. I think every judge has kind of hit on all of these, but addressing challenges using a team approach, that's one of the biggest drivers of this work. Using your role, if you're a leader, if you're a judge or whoever you are, or other stakeholders, using your leadership role and leveraging that to help make change, ensuring that your staff are well trained and provide quality services. The National Council can help with a lot of that training. And we also have our own conferences and can connect you to other trainings and conferences to go to. Focus on permanency and child well-being. We're here again. I think Judge Dixon touched on that, like opening up, like we're here for the child. We all talked about permanency. We don't want kids languishing in foster care. Collect and evaluate data. I love that Judge Dixon talked about data. That's a huge thing. How do you know you're making a difference? How do you know you have to have a baseline of where to start and where you want to go? So using that and leveraging that. And then obviously judicial advocacy goes beyond the bench. We talk about this in our enhanced resource guidelines, that your job does not stop just when you're on the bench. I don't know if we had any questions.
We just had one, and we may just have enough time to answer this one. It was using the timeline slide. So in 1899, the focus was creating separate courts for juveniles to address their delinquency. 70 years later, this migrated to focused on extended foster care concerns. The 2006 guidelines update seems to document guidelines to be followed to overcome languishing foster care and continuance delays. That said, today's milieu appears to demonstrate an increasing amount of juvenile delinquency, including gang initiations. The term feral teenagers is frequently used. How is or how not this increase in juvenile behavior is affected by the model court activities and actions?
Well, I will take a stab at that my county participated recently with a study with the National Center for Juvenile Justice, which is an arm of NCJ, FCJ, and that we are doing a study on dual jurisdiction youth, those youth that are in both foster care and the Department of foster care and juvenile delinquency court. And so we hope that I know we have a publication that will be coming out soon. I'll be speaking on it at our juvenile justice conference in March. And so that is absolutely an emerging field of study for us now. And we hope to be able to have some best practices to bring to you about dealing with that intersection very soon.
Yeah, and I can add to that we, in our court, we look at situations where the kids are duly adjudicated. We always looked at the delinquency side and the dependency side separately. Now we look at those children together, and most of those children who are being charged as a child are also the victim of the domestic violence or the substance abuse of their parents. And so we've discovered a way to try to not criminalize those children.
As well as typically, if a child is in dual jurisdiction, you're going to have the same judge. That's what we try very hard for, a one judge, one family, because we don't want a child to be under two plans. The plan has to be the same. We all have to be working towards the same goal. So you don't want a delinquency plan that conflicts with a reunification plan. And so they should be together. And that's why one judge, one family, which is a major feature of the model courts and implementation courts, is a huge focus.
So it also speaks to the importance of trying to coordinate the domestic violence cases with the delinquency and the child welfare cases. And so if you don't have coordination between those, then you have sometimes inconsistent rulings as it relates to the DV case that can impact, in a negative way, what's the goal that is trying to be accomplished in the child welfare case. So
it's an exercise in getting out of our silos.
Correct.
Correct. Awesome. Well, I think that was the only question we had, and we're only 1 minute over. We did great. I would love to thank our lovely 3 judges for being here today and everybody who joined us today. If you end up having questions you didn't get answered, you can send questions to the email on here, or you can feel free to reach out to Fabi and we can field them to our judges as needed. As a reminder, there'll be a survey after this. Please complete that. Let us know how we did. We use that information to help inform future webinars and future work that we do. And you will receive some emails from Fabi regarding CLEs and CLUs and other things as well. So thank you all, and thank you, judges, for being with us here today.
Thank
Thank
you.
you,
Thank
Cassandra.
Have a
you.
great weekend, everybody.
Thank you. Great
You
to see
too.
y'all.
Keep up the great
Good to see
work.
you. Yes.
Bye now.
Bye.
Goodbye.